Good morning, sir. I'm Kiara Bautista Morales for CRI A1-4. Our Group 3 report is all about SAS 12. Lesson titled, The Republic Act 9285, Alternative Dispute Resolution Act of 2004, and Other Applicable Policies. Lesson objectives. At the end of this module, students should be able to interpret the salient provision of Republic Act 9285, classify the different provision of 9285. Republic Act number 9285, an act to institutionalize the use of an alternative dispute resolution system in the Philippines. Act to establish the Office for the Alternative Dispute Resolution and other purposes. Chapter 1, General Provisions, Section 1, titled, This Act shall be known as the Alternative Dispute Resolution Act of 2004. Section 3, Definition of Terms, the purposes of this Act. The term, which is Alternative Dispute Resolution System, means any process or procedure used to resolve a dispute or controversy other than by adjudication of a preceding judge of a court or an officer of a government agency as defined in this act, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini or any combination thereof. Sa Alternative Dispute Resolution po or ADR, it is hereby to declare the policy of the state to actively promote party or the freedom of the party to make their own arrangements to resolve their disputes. Ito yung mga nag-a-assist ng resolution na na-encounter natin na kapag may issues, ano nga ba dapat ang gawin? Dapat gumanap ng paraan or gumawa ng paraan para mabigyan ng solusyon yung problemang meron tayo. ADR provider means institutions or persons accredited as mediator, conciliator, arbitrator, neutral evaluator, any person exercising similar functions in any alarma 5 dispute resolution system. This is without prejudice to the rights of the parties to choose non-accredited individuals to act as mediator, arbitrator, or neutral evaluator of the dispute. Whenever referred to this act, the term ADR practitioners shall be referred to individuals acting as mediator, conciliator, or neutral evaluator. Sa ADR provider po, dito po yung mga nahalo yung mga individual na kaya nila maging independent. Kumbaga is meron silang sariling kakayahan para makayanan nilang gawin ng isang bagay. For example, sa mediator, a person who attempts to make people involved in a conflict come to an agreement. Pagka may dalawang taong nakipag-agreement, silang dalawa, may agreement sila or kasulatan na magtatayo sila ng isang restaurant. Tapos, ang gagawin ng isa is magkukuan siya. Sasang-ayon sila para ang role naman po ni mediator dito is sila yung nagpa-facilitate communication between the parties in conflict, they helping them to reach a voluntary resolution to their dispute. Yung mga nagbo-voluntary dito sa may event na to is sila yung kailangan mag-facilitate na dapat is tama yung ginagawa nila na walang halong kemehan na hindi naman related dun sa topic nila. Conciliator, a person who acts as a mediator between disputing people or groups. Sa conciliator naman is related lang siya dun sa sinasabi ni mediator. Arbitrator, for example, mga independent na tao, sila yung gumagawa ng paraan para ma-point nila ang settle ng dispute. Sa may arbitrator is lahat dito na nakapaloob is yung mga taong independent. For example, working student. Ano nga ba ginagawa nila? Nag-work sila habang nagtatrabaho sila para matustusan nila ang kanilang pag-aaral. Neutral evaluator. It is a process from the parties or their counsel present their cases between third party. Sa ADR provider nga po pala is nagbibigay ito sa mga mamimili or nag-uugnay sa mga karapatan ng mga sektor. And also, ADR used to describe various methods of resolving disputes without the use of litigation. Meron naman po tayong picture dito sa may ADR provider. ADR provider is the results from the survey of consumers indicate that the ADR process, ito rin yung kabilang sa court process or cheaper for consumers. C. Authenticate means to sign, execute, or adopt a symbol or engrave a record in whole or in a part intended to identify the authenticating party and to adopt, accept, or establish the authenticity of a record or claim. Ito po yung example ng authenticate. Yung example na to, cellphone. Paano nga ba mabubuksan ang cellphone kung walang password? Kailangan meron password or may mag-authorize sa'yo yung may-ari para ma-open mo yung password. Parang i-depend natin to sa topic natin na sa may authenticate na bago mo mabuksan yung isang bagay na may password, hindi mo siya ma-open kasi hindi mo naman siya alam. Arbitration means a voluntary dispute resolution process in which one or more arbitrators appointed in accordance with the agreement of the parties or rules promulgated pursuant to this act resolve dispute by rendering an award. Dito naman po sa may arbitration, lahat ng nagbo-voluntary dito under the dispute resolution, sila yung gumagawa ng paraan para ma-process or sundin ang mga rules na dapat is yung arbitrators is gagawa sila ng mga kasunduan para aware sila sa kung ano man mangyayari sa bandang huli. Tapos, ang nagre-resolve din ng arbitrator is kapag isang bagay is nakamit mo na, bibigyan ka nila ng award. Parang deserve mo naman bigyan. Thank you po.
Good day everyone. My name is Gian Aaron B. Feliciano from 4th year IA1-4. Arbitrator means the person appointed to render an award alone or with others in a dispute that is the subject of an arbitration agreement. Arbitrator, ito yung taong ina-appoint para magbigay ng final decision at sila rin yung pumapagitna para magkaayos yung dalawang partido. Arbitration award means any partial or final decision by an arbitrator in resolving the issues in a controversy. Award, ito naman yung arbitral decision or yung final decision ng arbitrator at binibigay yung award na ito after ma-resolve yung issue. Commercial arbitration. An arbitration is commercial if it covers matter arising from all relationships of a commercial nature, whether contractual or not. Commercial arbitration, from the word commercial, involved dyan yung mga business na kung saan yung mga international business transaction ay nire-resolve sa pamamagitan ng arbitration agreement. Confidential information means any information relative to the subject of mediation or arbitration expressly intended by the source not to be disclosed. Example nito yung ang ibig sabihin nito is yung information, dapat yung information na yun is nasa company nyo lang or yung nasa group nyo lang. Hindi dapat malaman ng ibang tao yung information about dun sa company nyo. At ito yung mga example na hindi dapat malaman ng ibang company. Communication, oral or written, made in a dispute resolution proceeding. Kasama dyan yung memoranda, notes or work product of the neutral party. Pangalawa naman, oral or written statement made or which occurs during mediation for purposes of considering, conducting, participating, initiating, continuing, or reconvening mediation or retaining a mediator. At yung pangatlo, pleadings, motions, manifestation, witness statement, reports, filed or submitted in an arbitration. Convention award means foreign arbitral award made in a convention state. Ito yung pagbibigay ng award na ginaganap sa ibang bansa, katulad ng Global Peace Award or Inspiring Filipina Entrepreneur. Ayun yung mga award na example.
Good day, sir. My name is Rainiel Ignacio from 4CR A1-4. This is the continuation of the report. Conventional state means a state that is a member of the New York Convention. Ang sinasabi, sir, dito sa may conventional state, ito ay isang malawakan na grupo ng tao na kinakatawan sa bawat bansa. Dito ay binubuksan yung saligan batas para di lang amyandahan, kundi i-revise o i-total overhaul o i-total revision. And dito naman po sa may court as referred to in Article 6 of the Model Law shall mean Regional Trial Court. Ang sinasabi naman, sir, dito sa may court, ito daw po ay isang court ng batas, isang tao o grupo ng tao na may otoridad sa panghukuman upang pakinggan at lutasin ang mga hindi na pagkakasundo-sundo sa kanilang mga kaso. Ang Regional Trial Court, tinatawag din ito na Second Level Court. Dito rin sa may Regional Trial Court, yung jurisdiction dito over criminal case. Possible na penalty rito is umabot ng more than 6 years imprisonment. Ang RTC din ay tinatawag na general. Kasi kapag ang isang kaso ay wala sa jurisdiction ng ibang korte, halimbawa sa MTC, sa Court of Appeal, sa Sandigan Bayan, ang may jurisdiction dito, walang iba kundi yung Regional Trial Court. And next is Court Annex Mediation. Means any mediation process conducted under the auspices of the court after such court has acquired jurisdictions of the dispute. Ang sinasabi naman, sir, dito sa may Court Annex Mediation, ang pagsubok na ayusin ang isang kaso sa tulong ng mediator. So, ang ibig sabihin ng korte, bago humantong sa lubusan pagdinig sa isang kaso, baka pwedeng idaan muna sila sa Court Annex Mediation. Ibig sabihin na magtatalaga ng isang tao na mamamagitan sa dalawang partido at doon baka makita yung may compromise na maganap o yung agreement na siyang isasubmit sa korte. At yun yung ilalagay doon sa may kaso nila. And next is Section 4, Electronic Signature in Global E-Commerce o Global and E-Commerce. The provisions of the electronic signatures in global and e-commerce and implementing rules and regulation shall apply to proceeding contemplated in this act. Ang sinasabi, sir, dito sa may Section 4, Electronic Signatures in Global and E-Commerce, ito po ay isang pamamaraan na kung meron agreement na magaganap both of the parties and meron document na kailangan na i-signature, then ito ay allow na gamitin kung ito yung napagkasunduan nila. And next naman po is Section 5, Liability of ADR, Provider and Practitioner. Yung ADR is ito yung Alternative Dispute Resolution. The ADR providers and practitioner shall have the same civil liability for the acts done in the performance of then duties as that of public officer as provided in Section 38, Chapter 9, Book of the Administrative Code of 1987. Ang sinasabi sir dito sa may Section 5 on liability of ADR provider and practitioner. Dito naman po is nagbibigay ng pagkakataon upang maiayos sa tamang paraan ang isang suliranin o yung alitan sa pamamagitan ng dalawang partido. Hinihikayat nito na gamitin ang proseso para mabilis yung pagkamit ng hustisya ng bawat isa at layon din na mabawasan ang kaso na nililitis sa mga korte. Sa ilalim din ng Alternative Dispute Resolution System ay maaari din magamit ang mediation, conciliation, arbitration, and any combination para maresolba agad yung hindi pagkakaunawaan sa dalawang partido. And yun lamang po sir, maraming salamat po.
Good morning, sir. My name is Jacinto Aldrin Davdi from Group 3 and this is my report. Section 6. Exception to the application of this Act. The provision of this Act shall not apply to resolution or settlement of the following. A. Labor dispute covered by Presidential Decree No. 442, otherwise known as the Labor Code of the Philippines, as amended and its implementing rules and regulation. Sinasabi sa Presidential Decree No. 442, Labor Code of the Philippines, a decree instituting a labor code, thereby revising and consolidating labor and social laws to afford protection to labor, promote employment and human resources, development, and ensure industrial peace based on a social justice. B. The civil status of a person. Sa civil status ng person, halimbawa kung single or marriage. C. The validity of marriage. Validity of marriage, sinasabi dito na kung valid ba yung kasal na meron sila. D. Any ground for legal separation. Sa separation naman, kung nagkaroon ba sila ng legal separation na naganap. E. The jurisdiction of courts. In simple words, jurisdiction can be defined as the limit of judicial authority or the extent to which a court of law can exercise its authority over suits, cases, appeals, and other proceedings. As a matter of fact, every suit should be instituted before the court of lowest jurisdiction. F. Future legitime. G. Criminal liability. And last, those which by law cannot be compromised. Chapter 2, Mediation. Section 8, Application and Interpretation. In applying, construing the provision of this chapter, consideration must be given to the need to promote candor parties and mediator through confidentiality of the mediation process. The policy of fostering prompt, economical, and amicable resolution of dispute in accordance with the principle of integrity of determination by the parties, and the policy that the decision-making authority in the mediation process rests with the parties. Section 9, Confidentiality of information, is defined as information to which the public does not have general access. The policy governs the use or further disclosure of such information. Information obtained through mediation proceedings shall be subject to the following principles and guidelines. A. Information obtained through mediation shall be privileged and confidential. B. A party, a mediator, or a non-party participant may refuse to disclose and may prevent any other person from disclosing a mediation communication. C. Confidential information shall not be subject to discover and shall be inadmissible if any adversarial proceeding, whether judicial or quasi-judicial. However, evidence or information that use otherwise admissible or subject to the discovery does not become inadmissible or protected from discovery solely by reason of its in a mediation.
Good day sir and classmate. Ako nga po pala si Jexter Labios. At ito po ang aking report. Letter D. Sabi dito, ang mga sumusunod daw na taong kasangkot o sa dati magpapagit na ay maaari daw hindi mapilit na ibunyag ang confidential na impormasyon na nakuha sa panahon ng mediation. Halimbawa ako sumusunod ako sa patakaran. Hindi ko maibunyag kasi sumusunod ako. Pero kung hindi ako sumusunod sa patakaran, lahat ng pwede ko ibunyag, maibubunyag ko. Then letter E. Sabi naman dito sa letter E, the protect of this act shall continue to apply even if a mediator is found to have failed to act impartially. Sabi dito sir, ang mga protection daw ng batas na ito ay magpapatuloy na mag-apply kahit na ng isang mediator na hindi na napatunayang nabigo na magkaroon ng walang kinikilingan. Then F. A mediator may not a call to testify to provide information got in mediation of mediator who wrongfully subpoenaed shall be full cost of his attorney fees and related expenses. Sabi naman dito sir, ang isang mediator daw ay maaaring hindi tawagan upang magpakatotoo, upang magbigay ng impormasyon na nakakalap sa mediator. Ang isang mediator daw ay dapat bayaran ng buong gastos. Ang isang mediator daw sa puwan niya ay dapat bayaran ang buong gastos ng kanyang mga bayarin sa abogado at ugnayan ng batas ng gastos. Then Section 14. Participate in mediation. Participate in mediation. Ang participate mediation kapag ang mga partido daw ay sumang-ayon sa isang progreso na pamamagitan, mayroon silang kapangyarihan na maibigay sa kanila upang makarating sa kapwa o katanggap-tanggap na solusyon sa katanggap-tanggap na solusyon. Ang mediation daw ay dapat walang kinikilingan, walang pinoprotektahan. Walang kinikilingan, walang impluwensya o kontrol sa kinalabasan. Halimbawa ako, sa kapitbahay namin nag-away, dapat ako ang magiging mediation o hindi ko sila wala akong kikilingan, wala akong kinikilingan. Kailangan patas, parang ganun sir. Then section 15. Section 15. Section 15, place of mediation. Ang mga, sabi naman dito sir, ang mga partido daw ay ang mga parties daw ay malayang sumang-ayon sa lugar ng mediation. Pagkabigo sa mga sinasabing kasunduan, ang lugar ng pamamagitan ay magiging anumang lugar na maginhawa at maangkop sa lahat ng partido. Then section 16. Section 16, effect of agreement to submit dispute to mediation under institutional rule. Ang anuman daw institution ay dapat magsama ng isang kasunduan upang ma-invite ng panloob ng mediation at ang mga karapatan daw sa pangangasiwa ng naturang situation. Naturang institution. Dagdag daw dito ay ang isang kasunduan upang ma-submit na isang pagtatalo sa mediation sa ilalim daw ng international mediation rule. Yun lang po. Thank you po.